Welcome back, Law Kids, to the second installment of a lecture series on the history of Canadian law. In our last lesson, we looked at some of the more ancient civilizations that have influenced the legal system that we have today. We looked specifically at Babylonia and the Code of Hammurabi. We looked at Mosaic law and the Ten Commandments. We talked about ancient Greek law and the introduction of the jury system and voting and democracy. And then we also looked at Roman law and the codification of law in the 12 tables. And we talked about the introduction of legal advocates and the lawyer Cicero. We also talked about Justinian's Code. Today, we're going to bring it forward a little bit and talk about stuff that really only goes back, 1,000 or 2,000 years. So let's get started. Before I dive into the first legal system, I just want to let you know and give credit to the authors. I'm going to be quoting several times today from a grade 12 law textbook put out by Oxford, Canada called Canadian and International Law. The lead author is Anise Blair. And I just want to be transparent about that because, well, citing your sources is important. So, I don't think it'll come as a surprise to you that one of the major influences, if not the major influence, on our legal system is the British common law tradition. Of course, Canada is a former colony of Great Britain, and our legal system as well as our political system is modeled after theirs. Our House of Commons is set up in exactly the same way, and so is much of our court system. But if we go back to the origins of Britain's legal traditions, it's interesting some of the things that carry forward. So we're talking about the period, the reign of King Henry II of England at this point. He comes in and inherits a system that really has been um, kind of spread out and decentralized for a long time. Back when William of Normandy conquered England in 1066, there was a system of law, but as I said, it was decentralized. There was the feudal landholding system, and pretty much any landholder or baron was kind of a law unto themselves. They decided cases that happened on their territory, and of course, the decisions in one county could be wildly different than the decisions in others. And so legal reforms brought in by King Henry the second, his dates are 1154 to 1189. He sets up a system of traveling judges known as circuit court judges. And they go around and they listen to cases throughout Great Britain. And at first, it's kind of difficult for them to overcome local traditions in deciding cases because people are sort of really stuck in their ways. But as new situations arise, the judges are able to start to create new law. And then when they come back to London, I'm guessing, they start to talk to each other and write down sort of the key themes that are coming up. And this is the beginning of what is called common law. Now, I think at this point, I want to stop and explain the concept of a precedent. And I'll use this analogy. Let's say that we're inside a school building during normal times, and it's the first week of class, and a student comes in to my classroom 5 minutes late. And I stop them and I say, "Hey, you're 5 minutes late. Come and see me at lunch. You have a detention." What's happened in that moment is I've established a precedent. I've shown everybody what my decision is. And then what they're expecting or hoping, I guess, is that the next time this happens, if somebody comes in 2 days later and they're 5 minutes late as well, and I say, "Oh, don't worry about it, sweetheart. It's okay. Just sit down." Well, obviously, people are going to be upset and see that the situation is unfair. So, this idea of making decisions in cases that are consistent with the way previous cases were decided is really something that develops during this period. And it's called precedent law. So, lawyers urge the judges to make a decision that is similar to another case that was made in the past. Just before I switch slides here, when we're talking about the common law system, all of the countries that you see on that map that are red still use a system of common law. Now, be careful with that term because it can actually have three meanings. So it refers to this law that comes from Britain, right? Gathering up case law and looking at precedents. It also means quite literally law that is common to all, meaning that it applies to everybody in the land. And it also refers to law that is based on the past decisions of judges, that is, judge made law or case law. So, as I just showed you on the map, the common law system is used in many different countries around the world. Um, it is used in all provinces and territories in Canada, with the exception of Quebec, and I'm going to talk about that a little bit later, where there's a civil law tradition there that really goes back to Napoleon and their code. Oh, okay. Just before no, it's okay. I'm going to go ahead. Another really significant thing that comes to us from Great Britain is a legal document known as the Magna Carta. It's signed by King John of England in 1215 AD. Now, King John was widely recognized as a pretty terrible king. And his barons basically rose up and said, look, you're an awful king. You keep stealing our land. We've had enough of it. You're using the feudal system to elevate your friends by giving them land, and then you're taxing the daylights out of the rest of us. So we need you to sign this document in order for us not to rebel and overthrow you as king. But what is contained in this document is hugely significant. When we've been talking about the rule of law, the concept that the law applies to everyone regardless of their status was really not an idea that found expression until this document. You see, prior to the Magna Carta, there was a belief in Western European nations, a concept called the divine right of kings. So people were encouraged to believe that kings and queens had their position because it was ordained by God, that kings and queens were literally the representatives of God on earth. And when they made a statement, God was speaking through them. So if they said, the following thing should be a law, well, you would never question that because the king or queen was God's spokesperson. Well, of course, what we know is that kings and queens are still just basically humans, and they're flawed and they make mistakes, and they can be petty and they can be jealous and they can be immoral and they can do terrible things. And, England certainly has a colorful history of unusual characters in the royal family when you go back to that period. So the barons had quite enough of that. Thank you very much. They no longer believed in the divine right of kings. But this document, the Magna Carta, says on paper for the very first time that no one is above the law, not even the king. That's really the fundamental concept of it. Now, there's a lot more in it. There's 63 different clauses. There's a lot there about the right to due process, the right to a fair trial, and that kind of stuff. As I said earlier, it's really the foundation of the rule of law that all people and institutions are subject to the law, no exceptions. And there's also a reference to the concept of habeas corpus. I told you in our last lesson that you were going to hear a lot of Latin in law class. Here we go. Habeas corpus is Latin. The literal translation is to have the body, the body of the person. And because torture was widely used during the Middle Ages, a writ of habeas corpus was a written document that that demanded that a person who had been arrested should be taken from the cells where they were being held and brought into court where they could be seen by other persons, that to prove specifically that they were still alive and not being tortured. Take a look at King John's face in this painting. He looks really happy to be signing that. But because he signed it, he got to stay on as king. So, legal significance. So what? The Magna Carta really matters because it says that no one's above the law. This becomes an integral part of the concept of rule of law. And British tradition also, I should have included this in the text on the slide as well, brings us this concept of the rule of precedent, or as we'll see later, something called stare decisis. Now, I want to pause here and play this video clip. I'm going to take my headphones off and hope that the sound works okay. But if it doesn't, you may have to go into the original PowerPoint and click on this link to watch the video. So here we go.
This may look like a plain, unassuming piece of parchment, but is actually one of the most famous documents in the world. Magna Carta, meaning the Great Charter, has inspired people across the centuries, from Thomas Jefferson to Mahatma Gandhi. But why was the Charter originally created, and what does it actually say? Let us take you back to medieval England. It's the year 1215, and the ruler is King John. Many people believe that King John was one of the worst kings in history. He imprisoned his former wife, he starved his opponents to death, he allegedly murdered his own nephew, and pulled the beards of the Irish chiefs. King John had imposed heavy taxes on his barons in order to pay for his expensive foreign wars. If they refused to pay, he punished them severely or seized their property. The barons demanded that King John obey the law. When he refused, they captured London, and John was forced to negotiate. The two sides met at Runnymede in June 1215. The result of the negotiations was written down by the king's clerks into the document we know as Magna Carta. Although most of the Charter's clauses dealt with medieval rights and customs, Magna Carta has become a powerful symbol of liberty around the world. The most famous clause, which is still part of the law today, for the first time gave all free men the right to justice and a fair trial. No man shall be arrested or imprisoned except by the judgment of their equals and by the law of the land. To no one will we sell. However, this clause was not as liberal as it sounds. The Charter only applied to free men. The vast majority of people in 1215 were unfree peasants who were ruled over by their landowners. And although Magna Carta was intended to create peace between King John and his rebellious barons, England was plunged into civil war after the Pope declared the Charter invalid. When King John died of dysentery in 1216, 9-year-old Henry III took to the throne. To keep the peace, Magna Carta was reissued several times during the 13th century, until it was finally made part of English law. Magna Carta has lived on for 800 years and is echoed in the United States Declaration of Independence and the Universal Declaration of Human Rights. Perhaps Magna Carta's most important legacy is that everyone, including our leaders, must obey the law. What started out as a document of specific complaints from a group of barons has turned into an international symbol of liberty, without which we might not have the rights we value so much today.
Okay, I hope the sound on that came through all right. Let's return to our presentation here. Oh, by the way, just a reminder that in many of my PowerPoints, there are notes underneath the slides. So it's always a good idea to go and check there. Sometimes I've included some fun little tidbits that can just take things a little bit deeper. So we're going to move on next and talk about the influence of French law on Canada's system. I've already hinted at that in terms of its influence on the civil law codes of Quebec. And once this finishes loading, I'm just going to make sure. Okay, yeah. So we're here. So now we're talking about a period in time in the late 1700s, early 1800s. France undergoes a massive revolution. They kill off their monarchy. It's a very bloody revolution. Lots of people have their heads chopped off by guillotines, and it's a really bloody overhaul of French society. Um, and as France comes out of that revolution, they're looking for stability, and it's interesting because there's still very much a yearning for the stability that comes from a king or a queen or an emperor. So Napoleon comes to power and ultimately becomes quite a strong sort of dictator emperor figure himself. But one of the positive things that comes out of this period is the modernization of the French legal system. Um, of course, Napoleon names his new legal code after himself, and it is incredibly comprehensive. It's one of the first modern written codes, legal codes. And of course, as we know, we said in the last lesson, it's heavily influenced by Roman law. Now, the Napoleonic Code is divided into four categories, and this is why these four categories really give it away as being civil law as opposed to public law that involves things like constitutional law and criminal law and that kind of stuff. The Napoleonic Code really focuses on disputes between people, so things like family law. It looks at property and the acquisition of property, and civil procedure. If you're going to sue somebody, what is the process for doing that? Gone are all sorts of references to religion. The laws, as they're expressed in the code, are much more rational. There's been a huge explosion in logical and rational thinking. And by contrast to the British system, there is no use of case law. There's a really strict adherence to all that judges must do is look at the legal code, and that will tell them what to do. So the law is whatever is decided by the legislature. And we'll unpack this a little bit more later in the course um, when we talk about the Charter of Rights and Freedoms in Canada, because there were a lot of people who were against the idea of a charter. They believed that the law, as passed by Parliament, should be the final say on what's decided. And in Canada, of course, we have things that are a little bit different. The other thing that's interesting is that the French legal system is an inquisitorial system as opposed to an adversarial. Now, those are big words. Adversarial is the British system. You have a crown attorney prosecuting the offender and a defense attorney defending them. And they go into the courtroom and they do literally verbal combat. The inquisitorial system is quite different, and it's actually one of my goals to go and watch a trial in either Quebec, or I'd love to watch a trial in France someday. But the inquisitorial system is quite different. In our system, you can be accused of a crime, and you go into court, you enter your plea, and you say nothing. After that, your lawyer does all of the talking. You are not obligated to take the stand and say anything in your own defense. But in France and in systems that follow the Napoleonic Code, the inquisitorial system is much different. The accused is obligated to answer questions from the prosecutor, so they have to take the stand. They will also answer questions from their lawyer, but this is interesting. The judge actually asks questions. Now, I don't know how much legal TV or how many movies you've watched, but I've never seen a system where a judge directly asks questions, like repeated, extended over an extended period of time, asking questions of the accused person. Judges in this system actually take the lead in questioning the accused, and they can insist that the accused explain anything that may touch on the crime before the court. So they can ask questions about the emotions, the thoughts, the actions of the accused, and none of this would be allowed under the rules of evidence in Canadian courts. So it's quite different. So this legal system, the Napoleonic Code, also spreads around the world, and you can look up and find a map where that similar to the one that I showed you for Britain, that shows you all of the different places that use that Napoleonic code. One of them, interestingly, is Quebec. Now, when the British beat the French on the Plains of Abraham, and conquered what was up to that point New France, one of the compromises that was meted out was the French people who had colonized most of southern Quebec by that point insisted that they be allowed to keep their legal system. And so in the Quebec Act of 1774, that right was actually guaranteed to them. So because of that document, the civil law system based on the Napoleonic Code is still in place. And interestingly, because of this, because the Supreme Court of Canada has 9 judges, and some of the cases that come to it come from Quebec with a different legal tradition, there is actually a rule that says that at any given time, 3 of the 9 judges on the Supreme Court must come from Quebec so that they're familiar with that system. So that's a big significance. All right, we are coming into our last system. And perhaps in some ways, this one should be first, but I kind of wanted to save the best for last. Um, I think it's fair to say that Aboriginal law hasn't had a huge influence on Canadian courts in the first 100 years of Canada's existence. But that is changing now as we are paying more attention to the history of our Indigenous people and learning more about their culture and their traditions. Now, of course, me as a white settler descendant, um, I have to recognize, and we all have to recognize, that long before contact took place with Europeans, the Aboriginal people were here. They had vibrant economies, they had legal systems, they had systems of government. And just because we haven't learned much about them until recently doesn't mean that that isn't the case. Um, Now, one thing that's different and poses some challenges in a legal sense is that many of the laws that existed in Indigenous societies were passed down orally through storytelling and oral tradition. And Western civilizations tend to look at oral tradition as somehow less valid or less reliable than things that are written down. But it's important to know that there was one legal code that was written down. It was called the Great Binding Law. Um, and it was translated and written down, translated from things on wampum belts, similar to the one that you see in the picture there. The Great Binding Law covered many of the same areas as other legal codes that we've looked at, including things like emigration, treason, and secession. It also outlined many of the principles of justice and fairness that you would find in other civil rights documents. But get this, its underlying principle was that since hierarchy is what breeds conflict, let's pause for a second there and unpack that. So, a system where some people have more money, more power, more influence than others, that's a hierarchy. So, the belief was that since hierarchy breeds conflict, the Confederacy would need to organize in a way that prevents the rise of hierarchy. So, in the Great Binding Law, the Six Nations, that would be the Mohawk, the Onondaga, the Seneca, the Oneida, and the Cayuga, and then later um, joined by the Tuscarora, the Six Nations outlined historical reasons for conflict and addressed them. They noted that territorial hunting grounds were often the source of conflict. And so they abolished the importance of territory, decided instead to welcome those who entered their territory, and then guarantee the visitors' safety. When the founding fathers of the US were writing their constitution, they borrowed heavily, actually, from the Great Binding Law. So that's one legal document that's really significant. Um, Now, I've been lucky enough to see this wampum belt. I'm not sure if it's the original wampum belt or a painting of it, but I've seen this. I took this photograph at the Osgoode Hall Court of Appeal in downtown Toronto. And take a look at what it says here. The belt symbolizes the agreement and conditions under which the Iroquois welcomed the white peoples to the land. You say that you are our father and I am your son. We say, we will not be like father and son, but like brothers. This wampum belt confirms our words. These two rows will symbolize two paths or two vessels traveling down the same river together. So this is one vessel and this is one vessel. One, a birch bark canoe, will be for the Indian people, their laws, their customs, and their way. We shall each travel the river together, side by side, but in our own boat. Neither of us will make compulsory laws or interfere in the internal affairs of the other. Neither of us will try to steer the other's vessel. That's deep. And then take a look at the last line. This agreement has been kept by the Iroquois to this date. They've kept their end of this agreement. The question we have to ask ourselves, those of us that are non-Indigenous people, is have we kept our end of the bargain? And of course, this also really applies to when we're talking about treaty law. There are hundreds of treaties that were signed between Aboriginal people and the Europeans. And of course, one of the great tragedies is how many of those treaties were broken. Okay. I think I've talked about most of the stuff on this slide. But yeah, this is sort of the contents of the Great Binding Law. It's really actually interesting to read, and there's a hyperlink there if you want to go and take a look at the original document. Please let me know, by the way, if in any of my presentations there's a hyperlink and you come across a link that is no longer working. So let's get back to it. What's the legal significance? What's the so what of all of this? Well, one of the things that's having a big influence on Canada's legal system today is a very different approach to resolving legal disputes, specifically the consensus model. Look at the photograph and notice how different that is from the setup of a traditional Canadian or American courtroom. Instead of having the accused person on one side and the Crown or the prosecution on the other side and having them enter into an adversarial system, the legal traditions of our Indigenous people are very much based on consensus. And so everyone comes to the circle as an equal. Everyone comes expecting to share their truth. Everyone comes expecting to listen. And everyone comes expecting to compromise. There's an emphasis on healing, and there's an attitude towards crime that I find, frankly, quite refreshing. It's one that expresses the idea that when somebody commits a criminal act, it is not solely the personal failing of that individual and an expression of their bad or immoral character. It's also the failure of a community to help that person get to a place where they want to obey the laws of the community. And so people come to this circle asking not just, why did that bad person do that bad thing, but also asking, how did we fail this person? How did this person get so desperate or so disconnected from their community that they thought it was necessary to commit a crime? There's a huge emphasis on healing, that the work of reintegration of the offenders back into the community is really, really important. And that idea is gaining popularity today. I'm happy to say that. If you do some research on the concept of restorative justice, you'll see that it's something that the Canadian legal system is turning to more and more. The photograph that you're looking at there is of a sentencing circle. And this is something that's used for Aboriginal offenders in a lot of Canadian courts. They can choose to go to a sentencing circle rather than to have their sentence decided by a judge. But interestingly, sentencing circles are starting to be used with non-Indigenous offenders, specifically young offenders. And so what will happen is once somebody has been found guilty of an offense, they'll come to the sentencing circle and the entire community will decide what's the best punishment. So the accused has a chance to speak, the victim has a chance to speak, witnesses and other community leaders are allowed to participate, elders are present and offer their advice and their wisdom, and the community works together to come up with a sentence for the offender. Wildly, wildly different than the Canadian legal system or the traditional one that that we're going to spend most of our time learning about in this course. But I am going to try to do a lot of work on Indigenous law. So that brings us to the end of the formal part of this presentation. You now have everything that you need to have recorded in your organizer, which you're going to submit later this week. I want to end with some big questions, and we're going to discuss these in class, and I want you to think about them. All of these questions link back to the concepts of legal thinking that we learned about earlier in the course. So now that you've learned a whole lot about 8 different legal systems that have influenced Canada, I want you to think about the concept of continuity and change. If we were to go all the way back to the time of King Hammurabi and talk to him about what the world is like today, how much has changed and how much has stayed the same since King Hammurabi? You might look specifically at the issue of how the law has responded to changes in science and technology. We can also look at the issue of common themes that have emerged. Have you noticed that there are some things that all of these legal systems have in common, or maybe that 2 or more of the historical groups have in common? When we look at the issue of legal perspective, you've looked at legal systems that are, really different. To you, based on all of this reading and listening that you've done, what makes something fair or unfair? And have any of these historical legal societies gotten it more right than others? We can also look at the idea of interrelationships. What's the relationship between societal attitudes and the law? And we got into this a little bit in our last lesson about what is law and what is it for? Is law meant to reflect the values of the society, or should it be trying to push society ahead to a place that is more just? And lastly, the concept of legal significance. I want to know, of all of the codes that you've learned about in this lesson, which one do you think was most important? Right? Like I could assign you an essay question on that. Of all of the things that you learned about these different legal systems, which one do you think had the biggest impact on Canadian law? So I'll leave you with those questions to think about. We'll try to unpack them a little bit in class discussion. And our last slide is just a silly meme from Lawyer Dog. Thanks so much for listening to this, and we'll talk to you again next time.